Hey there, and welcome to this week's module. This week we are going over the court systems and appeals process, and we're going to talk about the type of court processes we have here in America. We have what we call an adversarial system in America, and that's really just a fancy way of saying that we have two sides of the court saying things to convince somebody that their side is right. They're battling it out. So we have the prosecution saying that they think or they're going to show that the defendant is guilty, and then we have the defense trying to show the defendant is not guilty. Because bear in mind, in the American criminal justice system, we don't find somebody in general, we don't find folks innocent. We just show that they're not guilty, which is not to say they didn't do it, just means the prosecution couldn't prove that they did do it. So that's a little bit of a nutshell on our adversarial system. And in part of that adversarial system says that because we're not an inquisitorial system, a little tough one to say there. Because we're not an inquisitorial system, we're not forced to take the stand and testify on our own behalf. We don't have to we don't have to say anything that would incriminate us. The Constitution, the Bill of Rights, gives us the right to be free from self-incrimination, or more aptly said, to be free from compelled self-incrimination. That's not to say that we can't go up on the stand and testify on our own behalf and then ultimately incriminate ourselves. It can happen. We just can't be compelled to do it. And now in modern times, we also, if we do enter a process in which we could ultimately incriminate ourselves, the criminal justice system, some sort of representative from the criminal justice system, has to let us know, hey, you might incriminate yourself if you go forward in this process. Uh, and so that kind of stems from some case law that happened, well, back in the 1960s. A guy by the name of Ernest Miranda. He was a bit of a sexual assaulter. He had committed some sexual assaults, or at least been suspected of committing some sexual assaults, and ultimately he was arrested for those crimes. At some point, the investigators decided they were going to interrogate Ernie and ask him. I'm paraphrasing here a little bit, taking some creative license, but essentially they asked him, "Hey, did you do it? Did you commit these sexual assaults?" And Ernie said, "Absolutely, I did it." He confessed. He was ultimately convicted, partially by using those confessions against him, because it's pretty easy to convict somebody when they confess to committing those crimes, and he was sentenced to prison. And then somebody told Ernie, "Hey, why'd you didn't have to confess that. That's not fair. Did they tell you didn't have to confess?" He said, "No, they sure didn't tell me. I didn't know. They asked me and I was just being honest. I didn't know I didn't have to talk to them. I didn't know I had the right to remain silent, or if I had known I could have had an attorney, maybe I would have called an attorney. None of that I knew." So he appealed his conviction. He appealed it through what is now the Ninth Circuit in Arizona. And the Ninth Circuit Court of Appeals said, "No, you're wrong. It's up to you. You should have known. It's your own fault. Go back to prison." And he said it's still not fair. So he ultimately appealed it to the Supreme Court. And Miranda v. Arizona, right in the 1960s, the Supreme Court ultimately came back and said, "You know what? That is kind of unfair. If you didn't know that you had the right to an attorney, and you didn't know that you had a right to remain silent, somebody should tell you. Those are some pretty important rights. Somebody should have told you." So here's what we're going to do. As with all the exclusionary rule, we know that in the exclusionary rule, the Fourth Amendment grants us the right to be free from unreasonable searches and seizures, and anytime evidence is obtained unlawfully or unconstitutionally, the entire case doesn't necessarily get thrown out. The exclusionary rule says that we're just going to look at this tiny little piece of evidence that's being appealed, in this case, Ernie's confession, and we're going to say, okay, this tiny little piece of evidence, this doesn't get to be used in court. You still have to go back and be retried. And that's what happened with Miranda's case. Ernie Miranda went back to Arizona. The prosecutor decided, okay, we are going to retry Miranda without the confession. And guess what happened? He was still convicted a second time because there was so much evidence against him. We didn't really need the confession to convict Miranda. He was that obviously guilty in his crimes. So a little bit of a lesson on Miranda, a little bit of a lesson on the exclusionary rule that says, you don't necessarily get the entire case thrown. In his case, he got retried and still convicted. He spent a long time in prison, and ultimately, he had a when he did get out, he had a hard time finding a job. And as most folks, as we know, in our society, once you get out as a felon, it's very difficult to find work. And Ernie was no exception to that. Ernie had a hard time finding jobs, and what he ended up ultimately doing, as the the story of his untimely death would tell us, that he was actually making a living, or at least making a side hustle, selling Miranda rights cards, because at that point Miranda rights had become a thing, had become a case law, had become somewhat famous, and Ernie Miranda was the name of the case law. So he was making a little bit of a side hustle by autographing and selling these Miranda rights cards, until ultimately when he was doing that in a bar at some point, he had an altercation, if you will, with somebody, and met his untimely demise in that bar. So that's as Paul Harvey would say, the rest of the story. But that's a little bit of an example of how our appeals process works through the system, ultimately to the Supreme Court, and then case law is ultimately formed. Case law is a part of where our laws are codified. We have the legislative bodies that write our laws, but also the judicial branch of our American system of government can also, quote unquote, write laws through precedent and through case law, and in the idea that these laws will be followed by the lower courts. So we have codified law through legislative branch. And we also have case law through the judicial branch. So hopefully that clears some questions you had up, or shed some light on a story maybe you haven't heard before. If you have any questions, as always, please, I look forward to having you reach out to me, and I look forward to reading your assignments this week. Enjoy your week.